Hi guys. There's not too much going on at the dockets at the moment, and I wanted to kind of put together something where I may try to answer a few questions that people have about what's likely to happen with this Section 47.1 fee motion that Lively has still got left open. Um, it's just my interpretation. That's really important to say. Right, other people may have different interpretations. That is perfectly normal, and encouraged even. Um, but this is just what I think and some of my own thoughts. Um, I will be talking about Section 47 and Section 47.1 generically, but I will be kind of trying to sort of say, and how I think it's going to affect Wayfarer or Lively, is this, and kind of applying it to the circumstances of. It's the Wayfarer v Lively case. It is not the Lively v Wayfarer case, and that is a really important distinction. Um, this motion still would have been there, um, regardless of what happened at the trial. So Wayfarer could have, and I did expect them to ask Lively to take it off the table as part of the settlement. They haven't. I have a theory. I have a theory on that, which we will get to. So I'm just going to kind of go into it and just walk you through it. Okay, so what we're going to be doing is looking at the framework of Section 47, which is the privilege statute, and then the anti-retaliation protection of Section 47.1. So we're going to start with Section 47. Okay, so what is it? It's a long-standing privilege statute which provides immunity from defamation liability for certain categories of communications. Now, where we will have seen it a lot, we've already seen it in the case in operation in this case and its related cases. So, Section 47B is litigation privilege, and that applies to statements that are made in or directly connected to judicial official proceedings, and they are absolutely privileged. And this is the broadest and most frequently invoked provision. We then have Section 47C. That's referred to as a common interest privilege. So that is it. This is not absolute. This is conditional and is based on good faith communications between parties sharing a common interest. They are conditionally privileged, provided they are not made with malice. Very similar to Section 47.1. There's got to be good faith, made without malice. Where this might apply is in the context of you get a new job, right? You apply for a new job. They want you give details of your previous employer or your current employer if you're still working for them, and your prospective new employer contacts the said former employer or current employer to ask about your, what were you like? What was your sickness absent like? What are your ethics like? Are you punctual? Have you had any disciplinaries? If you no longer work for them, they might say, well, they might ask, would you hire this person again? And, if anything's happened, like, especially in a disciplinary context where an investigation has been initiated, if information is, it comes to light that, say, someone, just say, for instance, right, it's keeping the same thread here. You're accused of sexual harassment in the workplace. An investigation was carried out, and your previous employer can divulge this information to your prospective new employer. Because, well, there's a common interest there. So as long as they're not doing it to be spiteful and it's all good faith, then that's how that would kind of apply. Then we have got the fair report privilege under Section 47D. Again, we have seen this one used in this case. This goes to accurate and fair reporting of official proceedings, such as court filings or government actions. It is privilege which protects journalists and commentators alike. So obviously, the New York Times were successfully dismissed from Wayfarer's complaint based on the fair report privilege. Lively was dismissed based on the fact that, she filed a CRD complaint and then very soon after went on to file a lawsuit. Okay, so the purpose of Section 47.1. California Civil Code Section 47.1 was enacted specifically to address the abuse of defamation litigation as a tool of retaliation. It recognizes that powerful parties may weaponize the courts to silence or punish those who speak out. And yes, absolutely, that is a problem. If a woman is, for instance, speaking out about her boss, how he sexually harassed her, or how he sexually assaulted her, then, it was not unheard of. It happened far too much where, they would initiate a defamation lawsuit and, usually the person sort of making the allegations is in a position where they don't have the resources to defend themselves. Quite often, especially in the workplace, because quite often you lose your job. So that is definitely a problem. Is it a problem in Lively situation? No. No, it's not. But it is a problem. I can see why the statute was enacted. I just don't like the way it's being abused right now by Blake Lively. So there are two prongs anyway to Section 47.1, right? There's obviously the deterrence, right? To discourage retaliatory suits for protected complaints. And then the remedy, prevailing defendants get attorney's fees and punitive damages to be made whole. But there is a contradiction here. The privilege that protects litigation communications may simultaneously shield the conduct Section 47.1 seeks to punish. The central jurisprudential question, can the act of filing a lawsuit simultaneously be privileged under Section 47 and penalised under Section 47.1? And what happens in either the New York court with Lyman or in the Texas court, because obviously she's filed the same motion for all of these remedies from Jed Wallace. So who's going to respond first, really? But, in either court, what happens is going to shape California's defamation law for years to come. So, the privilege of Section 47, specifically 47A, it grants broad, near absolute privilege to communications made in the course of judicial proceedings. And the rationale is foundational to open justice. Okay? So, free testimony. Witnesses must be able to speak candidly without fear of subsequent civil liability. Uninhibited pleadings. Parties must be free to advance legal arguments robustly, even if ultimately unsuccessful. And access to courts. The privilege is designed to ensure no chilling effect discourages legitimate litigation. Section 47A's privilege is absolute for statements made in litigation, yet Section 47.1 imposes penalties for bringing certain lawsuits. If Wayfarer's filings are privileged communications, can they simultaneously form the basis for sanctions? I suppose that's the big question. So the way I approached it was, on the one hand, you got the shield, right? Section 47, which is the shield. And then you got Section 47.1, which is the sword. Okay. So Section 47, the shield, protects statements and filings made in judicial proceedings from defamation liability. It's designed to preserve open access to courts and uninhibited advocacy, broad and near absolute in scope. Section 47.1, the sword, penalizes the act of filing a retaliatory defamation lawsuit without good faith, designed to deter weaponized litigation, requires courts to look behind the privilege to the purpose of the filing. And then in the middle, then you've got this conflict zone. Can a lawsuit that is privileged as a communication under Section 47 also be penalised as retaliatory conduct under Section 47.1? The statute points in opposite directions, yet both apply to litigation acts. Wayfarer argues that his pleadings are absolutely privileged under Section 47, which, if accepted, could foreclose Lively's Section 47.1 motion entirely. So, the court must reconcile two statutes that appear to operate at cross purposes. The resolution will likely turn on whether Section 47.1 is construed as a specific exception to the general privilege conferred by Section 47, or whether the privilege defeats the penalty claim altogether. On the one hand, you've got Section 47 pulling in one direction. It protects statements made in judicial proceedings and promotes open courts. And then on the other hand, you've got Section 47.1 pulling in the other direction, which punishes bad faith retaliatory defamation suits and deters abuse of process. Legal commentators, I say legal commentators at the moment, I know of myself, but I'm sure there are other people who are sort of just mulling over this. Section 47.1's specific enactment to address retaliatory defamation suits may signal legislative intent to carve out an exception to Section 47's broad privilege. Wayfarer Studios lawsuit, and again, is Wayfarer's lawsuit against Lively, not the other way round. The defamation claim. So, I was going to put it ends with this movie and so on and so forth. I took them out and just put Wayfarer Studios, but I forgot to take out the LLC. Wayfarer Studios and associated parties filed a defamation lawsuit against Blake Lively following her own legal complaints regarding alleged conduct during the production of It Ends With Us. Lively's complaint, CRD complaint, being turned into a New York Times article, appears to have directly triggered Wayfarer's defamation action, setting the stage for her counter motion under Section 47.1. So this is really important. Now, this Section 47.1, the retaliation, is for the lawsuit now, because she has settled her retaliation claims. Like, she has walked away from them for anything that went on in August 2024. So this is all about them filing that lawsuit, and specifically, it is not the entire lawsuit. It is just the defamation claim, and it is just the claim being against Lively, none of the other defendants, not Ryan Reynolds, not Leslie Sloan, not the New York Times. It is Lively and purely the defamation claim, so the civil extortion and breach of contracts, etc., emotional distress, none of that applies. Let's keep going. So the motion for fees and damages. Now, it's important to say, technically, she is the prevailing defendant, i.e., she successfully defended herself from a defamation lawsuit from Wayfarer. The judge dismissed the claim. Doesn't matter how she defended herself, the claim no longer exists. So, yes, it is more technical than it was no ruling on merits, but yes, she is still the prevailing defendant. So she has met that element. As the prevailing defendant following the dismissal of Wayfarer's lawsuit, Blake Lively moved for substantial relief under California Civil Code Section 47.1, which includes attorney's fees, that's full reimbursement of the legal costs incurred defending the action. That is just a defamation claim. So it will likely be an element of the motion to dismiss, maybe the motion to dismiss briefing, and probably the the fee motion briefing as well for, the Section 47.1 remedies. But nothing else happened, and really because it was they were consolidated, like the discovery and various other things that would have taken up a lot of time. They were, she had the benefit of them in her own lawsuit against Wayfarer. I don't think she can claim them. I think it would just be the motion to dismiss and the motion for bringing this motion, basically. Treble damages, triple the quantifiable harm caused by retaliatory suit. So Lively's got to prove that she was harmed, which we'll have a little look at later. I've got a really great visual. But she's got to prove that she was harmed and that specifically it was caused by Wayfarer filing that lawsuit. And she's not going to do it, and I will show you why. Then obviously punitive damages, and that's further damages to punish. But the damages, so that stem from harm, they would also be trebled as like a further punishment. So you've got punitive damages, but also they're going to treble the the harm, the nominal damages. It's like I'm working this out in my head. Like it's like punishment on punishment on punishment. It just feels a lot. Okay. What Blake Lively's Section 47.1 motion requires her to prove. So she has got to prove that her communications were protected. She's got to prove that it was without malice, that she had a reasonable basis, that Wayfarer's lawsuit was retaliatory in response. I put Lively filed suit when that should be Wayfarer. Prevailing defendant. She got to prove that. And harm was caused by Wayfarer's lawsuit. Okay, so the elements in detail. So the communication covered by Section 47.1, it has to be factual information about harassment or discrimination she personally experienced. It's also got to be made without malice. So no knowledge of falsity, no reckless disregard for the truth, no spite or ill will. Reasonable basis. So facts sufficient to justify a complaint, even if none was filed. A retaliatory countersuit. Wayfarer's $400 million lawsuit must be shown to target her protected speech. She was a prevailing defendant. She must have successfully defended the defamation claim, which I think she did. And she suffered harm as a consequence. So she's got to demonstrate that the harm she suffered, she's got to prove the harm, but then she's got to prove causation as well, which is got to be tied to the filing of the lawsuit. I wanted to talk a bit about malice, because I think malice is going to be, this is a conditional privilege, and it is based on good faith communications that are free of malice. Were Lively's free of malice? We all have an opinion on that. So to defeat the Section 47.1 privilege, you must prove the speaker acted with malice. Okay, so I'm back to general terms now. California applies the same malice standard used to defeat Section 47C and other conditional privileges. Section 47C is that common interest privilege. Malice is established when the speaker knew the statement was false, seriously doubted its truth, or acted with hatred, ill will, spite, or an improper motive unrelated to the truth of the allegation. There are two independent pathways to prove it. The first route is the knowledge of falsity or reckless disregard. This is the strongest avenue. Demonstrate that the accuser knew the allegation was false or seriously doubted its truth. And that is classic actual malice. But you don't need actual malice. You don't need to get to that bar. You just need, malice, to prove some malice. So some examples, right? And I'm sure everyone will be able to kind of like think to certain filings or moments in the evidence where we have seen some of this from, in this case. And this includes the stuff, by the way, in the Lively case as well, because again, it is consolidated. They are separate, but the evidence is on the same, basically on the same facts. Contradictory prior statements by the accuser. So the change in the color that was on the fabric that was supposed to be glued to her genitals, from nude to black. They will also be able to point as well, by the way, to other dockets, like Wayfarer could bring in her motion to dismiss in Jed Wallace's Texas docket and say, well, here she's saying that she was simulating nudity in New York, or she was nearly nude. Look, over in Texas, she's saying she was completely nude. She didn't even talk about a fabric, never mind the color of it. There are the state from we've got evidence that she was asking people to delete evidence, text messages, dailies. She then went into her deposition and said, no, I never asked for that. She also said she never asked anyone to unfollow Justin. And then Colleen Hoover went into her deposition and said, Blake asked me to. When asked the question, why did you unfollow Justin? I don't want to spend a lot of time because we will all have 1,000,001 and I can't sort of throw them all out, but they are there. So generally, the list is contradictory prior statements by the accuser, admission that the conduct never occurred. I don't think that's going to happen. Inconsistent timelines or provably impossible events. Fabricated or altered documents. Wow, ding, 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 we have a winner. Accuser's own messages contradicting the allegation. I would argue that, the messages to people like Sarah Rule, Ben Affleck and Matt Damon might contradict that. And Taylor Swift to a point, because at no point does she mention sexual harassment. She says that Sony asked her to take the movie. They took him off the director because he was inexperienced. Conduct after the incident was inconsistent with harm. So here, like the normal examples we'd see is a lot of friendly messages, praise, invitations, etc. So if we were talking about Isabella Ferrer, right, this would be so easier to put that as an example. Like she did her part, went away. She then, off her own steam, text Justin Baldoni, thanked him for creating such a safe set, best experience of her life, etc., etc. No one asked her to do that, and she was not responding to anything. She chose to do that. So the spin later on that, oh, well, that's the kind of thing you do, a young actress does. Why would she do that if she didn't believe it? Because it was not a response to anything. She just chose to do it. It would not make sense. And it still doesn't actually make sense. Like, why would you say he, specifically text him to say thank you? It was such a safe set. If that's not how you felt. And she only felt like that after talking to Lively. Now, how would I apply this to Lively though? Well, most people, especially in the employment situation, women who speak out about any kind of harassment of that kind against their boss or fellow employees, they often find it has a negative impact on their career. They don't get demoted. They may even get fired, right? A reason would be fluffed up, But for some, Lively seemed to get increased responsibility. She got a PGA letter, which got her a PGA mark, She got her cut the film. How this is not consistent with someone who has been harmed. It's not. Previously recanted and then stated intent to ruin the accused. Then there's route 2, ill will, retaliation, or improper motive. Now, I think we've got a lot here with this, so I'm not going to go through it in great detail. Even when the accuser believed the allegation, right? And this is important because Lively, after the order on the motion for summary judgment, Lively was then running round, and untraceable smear campaign was replaced with she had reasonable basis for believing, because she's mirroring her language. Retaliation claims were still in. She is now mirroring her language to the language of the legislation. And that's what she is telling everyone. Like, it's almost like, if someone says it enough, people start to believe it. And that's how she has kind of litigated this. So even where the accuser believed the allegations, malice may be shown through spite, revenge, leverage, or personal animus. I'm sure we are going to all go and put our hands up and say, yeah, I've got a million. I've just got so many examples here. Now, this is known as common law malice. And it can include retaliation following a breakup, firing, dispute, or prison. It can be attempts to gain custody, employment, and contractual leverage. Well, she gained custody of the film. She gained employment as a producer, which she wasn't previously. And then obviously the contractual leverage. I'm not going to do the promotion. I'm not going to do this. I'm not going to do that. I'm going to stop the author promoting the film. Threats to go public unless demands are met. Now, I haven't seen anything that directly says that she's going to do this. Wayfarer certainly believed it. So there may be something that exists somewhere that would back that up. But they believed that she was going to do that. Coordinate smear campaigns. Again, I could point to the emails to Matt Damon, to Ben Affleck, Sarah Rural. Not so much the cast, although she clearly did smear them, smear the cast against him. But, it's the outside people who did not work on the film, did not work with Justin Baldoni. These are big names as well in the industry who have influence and power. Matt Damon did contact Tim Rothman, the chair at Sony, to try and put pressure on Sony to use Lively's cut without even going through the contractual bake-off process, which Baldoni was entitled to. And we know Leslie Sloan was planting stuff. We know that. We've seen evidence of that. Statements such as "I'll destroy you" or "make sure you never work again," they really come from Ryan Reynolds. They wouldn't count because it hasn't come from Blake Lively directly. Although, the dragons, that was a bit of a threat, of all the power she wields. And, the fact that her and Ryan Reynolds kind of run their family and their connections like the mafia. Again, it sounds like, oh, we're very friendly and we're bringing you into our club, which I think Justin Baldoni was hoping it would be, but in reality, it's like, yeah, don't piss me off. That's what I hear. Timing linked to litigation commencement. I think there's better ones. Accuser encouraging others to repeat the allegation. Yes, she texted verbatim to Jenny Slate what she wanted Jenny Slate to say, pretty much. Do you remember when this happened and you said this and then he said that? And oh my God, it was so creepy. And they actually coordinated their speech. They were saying the same words. They were describing the same words. I can't remember what it was. But all of the women, Alex Sachs, Jenny Slate, Isabella Ferrer, they were all describing Justin or the way Justin was speaking, some of the things he did with a specific word, and they all started using it. And it was like, okay, one person may use that quite a lot, but for all of these women to be using it, that's really unusual because it's not like a word that would come to people's minds as the first word. Also, they were all calling them clowns. That actually now feels quite coordinated. Like, why would you think of someone as a clown? You know, it's just it's quite a specific word, and then it seemed to be being used a lot. And then celebrating reputational harm. Yes, I think there's evidence of this as well. I think the messages in December 2024, a couple of weeks before the CRD was filed and the New York Times article was published, between Blake Lively and Taylor Swift, where, you know, the article was only a couple of weeks before being published, and they were talking about how it was going to be the backlash to the backlash, and, you know, good, he deserves it, I can't wait, it'll be worth the wait, and that kind of stuff. You know, I'm kind of paraphrasing here, but yeah, words to that effect. Yeah, I think that would do it. Okay. Direct evidence. Okay, so what evidence courts treat as strong indicators of malice? And if you can get some of all three of these categories, it's even stronger. So direct evidence would be text or email showing spite, revenge, or an intent to harm. Admissions of exaggeration or outright fabrication. Statements made to friends or confidants that contradict the harassment claim. Again, we just talked through a bunch of stuff which could fit some of this. Circumstantial evidence. Accuser's account changes repeatedly across interviews or filings. Ding, ding, ding. We had that. She contradicted herself a lot. And, you know, I've kept a lot of records because I very closely watch all the dockets and I look for inconsistencies in Lively's filings. And there are, between the New York filings and the Texas one, some of them change. Obviously, the color of the fabric of her that was glued to her genitalia also changed when the video was released, showing that footage. Yeah. Accuser refuses to provide corroborating details or evidence, provably false factual assertions within the allegation. History of false accusations against other individuals. Well, there's that photographer that they had arrested. They made false allegations against that got him arrested. Lively's also made a false allegation of sexual harassment against a makeup artist because he used his finger to kind of apply her lipstick, which is not uncommon. Demonstrable motive to harm, financial, relational, or professional. Post-incident conduct inconsistent with claimed trauma or fear. Again, she took over the film, had her cut of the film. She was on the red carpet enjoying the premiere whilst everyone else was in a basement. She then skipped off to Capri to film Another Simple Favor, went to a few Taylor Swift concerts, and then from there on, she was so traumatized she couldn't get out of bed. So, you know, and I also I don't think people kind of grasp how important this is, right? For me, it's bothering me. All the so-called sexual harassment allegations took place in phase 1. There was then several months, and then they come back. Phase 2, Lively has no problem, you know, going and filming those scenes, which included some of the more sexual kind of scenes and the abuse scenes. And she was fine doing that. And then all of a sudden, she couldn't bear to sit with him to do promotional work, interviews. And neither could anyone else who also had not experienced any sexual harassment, nor had they seen, apart from Jenny Slate seeing that one incident, nor had they seen incidents of sexual harassment. Yeah, her conduct post incident does not make sense. And she had to pull her emotional distress claims anyway because she wouldn't give up her medical records, which would have, well, but clearly they didn't prove anything. I'm also believe as well, like, she wanted to seal the birth film of Natasha Heath because it did not show a close-up view of someone's vagina with a crowning head. I don't believe it did show any of that at all. That's why she asked for it to be sealed, and that's probably why Wayfarer clapped back and said, no, release it. But now it's not going to be released because, the claim is settled. And I'm happy with that. I've learned everything I need to know from the way Lively tried to keep it hidden. Procedural evidence. So, again, we're still talking generically here, but trying to apply this to the case. Accuser files with the press before any regulatory or agency complaint. Now, obviously, again, for Section 47.1, you don't need to have filed a complaint. You don't need to have filed a complaint. But in generic terms, like where you're looking for malice, these kind of things would be sort of evidence. I mean, she didn't file with the press before the regulatory, though. Even if it were applied, she did actually file the CID first. But obviously, we have the evidence that she was working with the New York Times months before. Selective leaking of information to maximize reputational damage. Well, she clearly chopped up the text messages to I think they were given to the New York Times like that. I think they were given to the New York Times already, selectively manipulated to give a narrative. So, yeah, because we've seen with Wayfarer where they put Lively's set of text messages in one way, and then they actually they showed the side by side with the real threads and the missing messages, which changed the narrative. So, yeah. Coordination with third parties to amplify and repeat the allegation. There we go. Okay, so why does this matter for Section 47.1 specifically? Section 47.1 protects only a communication made without malice. So the privilege is conditional if you prove malice on any of the recognized grounds and the statutory prove malice on any of the recognized grounds and the statutory shield collapses entirely, exposing the accuser to substantial civil liability. Okay, so grounds that would collapse the privilege. So I say an accuser, but obviously I'm talking about Lively as well. Accuser knew the allegation was false, seriously doubted its truth, or acted out of spite, revenge, or personal animus. The allegation was deployed as a weapon rather than a genuine report. Again, the 17-point list, right? But why do you need Todd Black? Lively said in her 17-point list he was to keep the set safe. Todd Black, in his PGA letter, said that he was brought on to help Lively realize her vision, her creative vision. Nothing about keeping anything safe. Same for the first AD, right? Ryan Reynolds says that the first AD was let go because she wasn't keeping the set safe, and it would have been one of the 17-point list. Well, it would have been 18 points. That would have been added to that return to protection letter, but they didn't need to because the AD was let go. But then in Lively's PGA letter, she says that she had to do that because the AD was inexperienced, much like when she speaks to Matt Damon about why she's been given the film, given control of the film. It's because Baldoni's inexperienced, not because he is predatory or sexually harassing her. So, yeah, that's what she does. I do think that the allegations were used as leverage, and were used as a weapon. And the next one is allegation made to gain leverage. Absolutely. Allegation made to humiliate or destroy the accused. Yeah, probably. Once malice is established, the communication is not privileged. The accuser bears the full weight of civil liability, including potential punitive damages for a deliberately false or maliciously motivated allegation. Now, obviously, If Lively had posted all these allegations, not in a CRD complaint and not through the New York Times, if she'd done it on her social media, then there would have been no litigation privilege or fair reporting privilege applied to dismiss them. So that claim may not have been dismissed, but it was. So we're not going to be I don't know what happens if Wayfarer actually prevail in this motion. Does Lively have to then pay for their fees and so on and so forth? Does she get hit with damages? It's a question I'm asking, but I don't know the answer to. A bit of hypothetical there. So who's got the burden of proof? Lively. She's got to demonstrate there was retaliation, that there was an absence of good faith in Wayfarer filing their lawsuit, that she is the prevailing defendant, and that she has been harmed, and there's a direct causation from Wayfarer filing the lawsuit to the harm. Okay. The major problems with Lively's Section 47.1 claim. For me, I found 6 quite significant weaknesses. So the first one is there was no ruling on Section 47.1. Right? When Judge Lyman dismissed Wayfarer's complaint, he specifically made a point of saying that he has not made any ruling on that on Section 47.1. He invited Lively, he was denying it effectively, but he invited Lively to refile her motion, which she did. But as it stands today, it has been entirely unaddressed by Judge Lyman. There is nothing about it in any of the filings. And he didn't have to either, because he was able to rely on the litigation and fair reporting privilege, which tells you how much he probably does not want to do this. I'll get to why. Problem B is proven retaliation is contested. So Wayfarer are arguing that their countersuit was legally legitimate, not retaliatory. If the countersuit had any arguable legal basis, Section 47.1's enhanced remedies may not be available regardless of the outcome. Now, obviously, that whole lawsuit was not just defamation, and it was not just Lively, but we are just looking at defamation and Lively. Now, the only thing is, Lively, he said that everyone else, it could have been a baseless lawsuit in terms of everyone else, but he did not make any comment regarding whether actual malice existed with Lively or not. He said there was no sort of Wayfarer hadn't shown that Ryan Reynolds had acted with actual malice, or Leslie Sloan, or the New York Times. But he did not make that same statement about Lively. He didn't say that a jury could find that she had acted with actual malice either. So problem C. So Section 47.1 is untested law. No appellate court has yet interpreted this statute. Courts may read reasonable basis without malice and prevailing defendant narrowly, particularly where dismissal was procedural rather than on the merits. And he did dismiss largely because of impermissible group pleading. You had people like Melissa Nathan and Jen Abel, making contract claims, civil extortion claims, which contracts they were never part of, and they were never extorted. So yes, that's why the lawyers were sanctioned as well, because in that regard it was a bad lawsuit, but it did the job of getting the defense out and getting the PR battle back on. It was won, and public support was shifted back to Baldoni. This is just a thought process, but for me, the settlement may complicate causation. So they've settled most of their claims on the Lively's lawsuit, but Wayfarer waived an appeal right. However, the settlement language may undermine whether Lively truly prevailed, whether the countersuit caused compensable harm, and whether damages remain legally appropriate. So, again, in terms of was she successfully dismissed from Wayfarer's lawsuit? Yes, she was. So, if that is all that's needed to be a prevailing defendant, I think it is. Then that might be enough. But I've left a little bit of is there a grey area here? Because again, there are questions on how this statute is going to operate in reality. Problem E. Communications must be factual, not promotional. So if any of Lively's statements were embellished or formed part of a PR strategy or were made outside the context of reporting harassment, they may fall outside Section 47.1's protected definition of communication. And then problem F, my favourite. Her own expert, Lively's own expert, seems to undermine the causation argument. So what do I mean by this? Dr. Dina Maislin, I've gone back and I've had a look at her, the bar charts that she put in her report. And her own charts show the highest negative online activity against Lively was the week she filed her CRD complaint, and the New York Times article was published, which was on the 21st of December 2024. Now, that was before Wayfarer's lawsuit was filed on I want to say the 15th or 16th. Yeah, 15th or 16th of January. Because they initially sued the New York Times in California. So, Lively then filed her own lawsuit on the 31st of December 2024. And then Wayfarer filed against New York Times in California, but not Lively. Lively was not a party. However, they did file a lawsuit against her in the middle of January 2025. And when I look at this chart, there was a huge spike when the New York Times article came out, and then it had significantly dropped by the time Wayfarer filed their lawsuit, and there was no noticeable kind of big spike from it. And I'm going to show you what I mean. So this is said graph. There's said bar chart, sorry. This is the unsupervised method. I have no idea what that means. I don't, but there is another one. Like there's about 4 actually, but I've used 2, which have the same, well, very similar results. So we have this first spike. That is the August time, which is now not part of this. She settled that claim. It's done. So this is irrelevant, but that's one spike. Yeah, this is the so-called backlash she's talking about, right? You had a week of a little bump, then a big spike, then a little bump, and then next to nothing. It had gone away, right? The next big spike, where the pink dots are, above it, is the week of the 22nd of December. And that was a huge spike. So that's the day after the New York Times was filed. That's the biggest spike on the entire page. And then we'll go to the green one, right? I put the color coordinated little like dabs in correlation with the dates, right? But because the dates are at an angle, I wanted to put them above the corresponding like bar, so you can see then where they are. And we're only looking at the red part of the bar, right? The red bit shows the negative sentiment, the yellow shows the mixed, the green shows the positive, and then the kind of grey shows the neutral. We're only looking at the red part of the bar, and you can see, right, a huge spike where the underneath the pink dab. Wayfarer, when they filed their lawsuit in January against Lively, you can see the green dab is above it. If it's a third of the spike that Lively's that the New York Times generated for, then that's all it is. And then the blue one is where Wayfarer then amended their complaint, but we're not talking about that. We're talking about when they filed a retaliatory lawsuit, which was above at the point where the green dab is. So yes, they amended their lawsuit on the 3rd of February. That's the blue dab. And it's still only about halfway up the big spike that the New York Times generated. And then Lively amended her lawsuit. And it was bang smack in the middle of 2 dates. So I put dabs above 2 bars there. And you can see it's a bit of a nod with the first one, a bit of a jump up with the first one. But then there's another big spike then with into the next week. Which is also arguably bigger than the spike that Wayfarer generated by filing their lawsuit. We had the same results on the direct method version of this graph. Again, I don't know what those terms mean, but I'm guessing that they are two different things, which have managed to get very similar results. I just want to show you what I did then. I took an orange marker and I drew a line, horizontal line, across all of the bars, but only so the top three, the three highest spikes would be just sitting above, right? Everything else would be under. And those three spikes, the biggest spikes in negative sentiment towards Lively online, were firstly her marketing of the film, which was piss poor. Her publication of her CRD complaint in the New York Times, the biggest spike. And then her amending her complaint. So from this graph, it looks to me like Lively smeared herself a lot. People reacted to her actions. It was her promoting her movie. It was her, article that she asked the New York Times to publish with her CRD complaint in it. And then it was her amending her complaint. So Wayfarer cannot be held responsible for the big spike when the New York Times article was published. They cannot be held responsible for that, but they also cannot be held responsible for the spike when she amended her complaint. It wasn't a huge spike with her initial complaint, her initial lawsuit, because that's to the left of Wayfarer's, the one with the green dab, where Wayfarer had filed their lawsuit. The bar to the left is the point where Lively filed her New York lawsuit against Wayfarer. There wasn't such a big spike there. It was, in fact, it was identical to Wayfarer's spike. But then we saw all the evidence and, people became intrigued naturally. And that makes complete sense why, when Wayfarer amended their complaint with things like the metadata and things, which were all over TMZ, people watched it, looked at it. We had the timeline as well, that Exhibit A timeline, which was an absolute gift from the gods. And we went in, and people then saw so much evidence. And then when Lively amended her complaint, I'm sure we all want to know, well, what's she going to say? What was she going to do? Didn't really say anything, actually. Certainly nothing that helped her. But people were pissed off because we'd now seen the evidence. But Wayfarer, she was not harmed. Like, how does this help her prove that she was harmed by Wayfarer filing a lawsuit? Because I don't see it, because she'd already, you know, destroyed herself by publishing the New York Times article. So we continue. Potential awards for Blake Lively: attorney's fees and costs, treble damages, and punitive damages. I won't go into that too much because we know what that is. But what impact could the ruling have on US law? Because this is going to be the first major judicial application of Section 47.1. So this is going to carry significant implications for accusers, defendants, and legislators across the country in either direction. If Lively wins, it's going to strengthen the protections for harassment accusers. Retaliatory suits carry severe financial consequences. It could encourage other states to adopt similar statutes, especially in, Me Too type contexts. It's going to expand privileged speech, which will broaden the shield for public misconduct allegations beyond formal complaints. And it's going to increase litigation risk for accused individuals, deterring defamation countersuits, even where allegations are disputed, as in this case, which is something I am a bit concerned about. And then if Wayfarer wins, it's going to narrow Section 47.1's reach, because the courts will interpret reasonable basis and without malice strictly, which I think they should. It reinforces that dismissed harassment claims do not automatically qualify for Section 47.1 protection. Again, something I agree with. It preserves defamation countersuits, so accused individuals retain the right to respond legally to false allegations. Again, I think this is so important. People have to be able to speak for themselves. They have to be able to respond to an allegation, especially where, in this case, you're dismissing it before any evidence, before anything is anything on the merits is ruled. You are. I find it very problematic, right, that someone can make an allegation and you can try to say, hey, look, you file a lawsuit, say that was false, it was defamatory, it caused me harm, which is your redress. That's your legal redress to that scenario. And it's dismissed at a motion to dismiss stage. And automatically it's taken as a given that just because they have said, hey, he's actually harassed me, that you've now got to incur all of this. Whereas if it hadn't been dismissed at the motion to dismiss stage, then it would have gone to trial and would have at least had a ruling on the merits. I could see the benefit in this. I could see the need for it as well. But for me, like, they should let this should only come in and be a factor at the end of a trial, not, or a settlement, not at a motion to dismiss. I just find that unpalatable, that someone is prevented from defending themselves. Slows legislative spread. Other states may hesitate to adopt laws courts interpret narrowly. So the Wayfarer's defence, but there's a few. There's obviously the Section 47B litigation privilege. All statements and filings made in defamation action are absolutely privileged communications in judicial proceedings, and therefore cannot form the basis of a Section 47.1 claim. Agree. And they are absolutely saying to Judge Lyman, hey, Judge Lyman, are you sure? Like, we're not going to appeal this, so this is going to be here until someone else, gets a judgment and then decides to appeal. This is gonna set the precedent until someone appeals this to a higher court and gets it overturned. And the thing is, right, is as the next box says, constitutional rights. Filing a lawsuit is a constitutionally protected right of petition. Penalising that act under Section 47.1 raises First Amendment concerns regarding access to courts. So is Judge Lyman going to be the one to put his name to curbing that right, to limiting it? See, this is the balance he's got to deal with, and I don't think he wants to do it. And there's obviously the extraterritoriality and scope. So there's obviously arguments that Section 47.1's application to the specific facts and parties in this case may exceed the statute's intended territorial and subject matter reach. You know, she is a New York resident, and the acts that she was complaining about took place in New Jersey. Why are we here with California law? Wayfarer being residents in California and 1 or 2 days of shooting the film during a time when there was no issues on set, for me, it just doesn't feel strong enough to tie Wayfarer to, to allow Lively the benefit of a California law. Okay, so summary and key takeaways. Lively, so Wayfarer and Lively dispute, it represents a pivotal test of California's newest defamation limiting statute. The outcome is going to shape the boundaries of protected speech for harassment accusers nationwide. So, firstly, Section 47, the foundation, California's general privilege statute providing absolute and conditional immunity for communications in judicial, official, and common interest contexts. 2, Section 47.1, the new shield, right? So it's a powerful anti-retaliation statute protecting those who report sexual misconduct with treble and punitive damages available against those who sue them for defamation. Lively's burden. She has to prove her statements were factual, made without malice, reasonably grounded, and that Wayfarer's countersuit was a direct retaliatory response to her protected communication. And I will say this, Judge Lyman, in the motion for summary judgment, Judge Lyman said a jury could find that Lively had a reasonable belief, but he did not say he agreed that she had a reasonable belief. She is trying to twist that. That is not what the judge said. Her key weaknesses, though. There was no Section 47.1 merits ruling from Judge Lyman. Her own expert's data undermines the causation. The settlement's effect on prevailing defendant status, I'm not 100% convinced, but I'll put it in there just because generally, I'm again talking generally. And the statute's entirely untested nature. National significance, whichever way the court rules, the decision will define how far states can go in shielding accusers from retaliatory defamation suits, with implications far beyond California. So, Section 47.1 remains entirely untested at the appellate level. Any outcome in this case should be treated as persuasive, but not controlling until higher courts have weighed in, as I said earlier. And then finally, a landmark legal test. The court's ruling will turn on a single fundamental question. Does Section 47.1 operate as a specific statutory exception to Section 47's broad litigation privilege, or does the privilege shield even retaliatory defamation suits from penalty? So if Lively prevails, Section 47.1 will be confirmed as a meaningful check on weaponized litigation with real financial consequences for bad faith plaintiffs. If Wayfarer prevails, Section 47's privilege will be confirmed as near absolute, significantly limiting the practical utility of Section 47.1 as an anti-retaliation tool. And the precedent, either outcome will set a significant benchmark for retaliatory litigation disputes in California and beyond for years to come. And that is that. Thank you so much for watching, everyone. If you can, please do like and subscribe and hype the video. It always helps me. I'm I'm gonna see what else there is. I might continue with the unsealings. I know I'm expecting a filing in the Wallace v. Lively docket, and, like a sort of one of my unrelated cases, the trial of the men accused of murder of Ian Watkins, the former lead singer of Lost Prophets, convicted paedophile, um, back in October. That trial is currently going on now in Leeds Crown Court. I am not there in person, but I have, access to UK courts. So I will be probably doing a week by week video just summarizing what's happened and any key points for those of you who actually follow that part of my channel. All right, guys, thanks a lot for listening.